So I'll start with my opening remarks then. Tēnā koutou katoa, a warm welcome to you all. Environment Canterbury, the Canterbury Regional Council, has proposed changes to two of its regional plans. They are Change 7 to the Canterbury Land and Water Regional Plan and Change 2 to the Waimakariri River Regional Plan. Numerous submissions on those proposed changes were lodged. Environment Canterbury appointed 3 independent hearing commissioners to consider and report on the amendments to the plan changes requested in the submissions. The commissioners are Raywin Solomon, Rob van Voorthuizen, and me, David Shepherd. Today we are starting public hearings of those submitters who want to be heard. Before we commence, I will just record that we understand our purpose as being constructive, finding in the submissions improvements in the plan changes that we could recommend to the Regional Council. Before we call on the first speakers, I would like the manager of the hearings, Ms. Fernando, to announce the emergency announcements, please.
So just some health and safety. Have you all signed in using the COVID app? And if you haven't, there's a sign-in sheet at the front. So if you can make sure you've done that. The toilets are just out of the door and to the right. The ladies are the first one just here, just outside, and the gents are a little bit further down the corridor. The earthquake and fire evacuation point is out of the door that you came in, outside on the street. And if you can make sure all mobile phones are switched off as well, please. Thank you.
Well, thank you for that. As is customary, we start with the presentation on behalf of Environment Canterbury.
Kia ora koutou katoa. Good morning, Commissioners. My name's Philip Moore and I'm Legal Counsel for the Canterbury Regional Council with respect to the hearings on Plan Changes 7 and 2. Sitting with me to my right is Ms Edwards, Legal Counsel, who will be assisting with this hearing process, and to my left is Mr McCallum Clark, the Principal Planning Officer with respect to some components of these plan changes. I have prepared some legal submissions, a copy of which I understand has been pre-circulated, and I don't intend to read those submissions. Rather, I intend to provide a very brief summary of the contents of those submissions before being in a position to answer any questions that the hearing commissioners may have.
Thank you.
Plan changes 7 and 2 are structured in 3 parts. Part A deals with changes to region-wide provisions and is referred to throughout both the Section 42A report and evidence as the omnibus part. Part B deals with provisions relating to the Ōrāri, Temuka, Opihi and Pari Order provisions of the plan. Those rivers will be shortened and you'll hear about the OTOP provisions in Part B. And finally, Part C deals with the part of the region known as the Waimakariri sub-region. And in addition to changes to the Canterbury Land and Water Regional Plan through Plan Change 7, changes are proposed to the Waimakariri River Regional Plan through Plan Change 2. In my opening legal submissions, a significant component of the submissions addressed the implications of the Actions for Healthy Waterways package, which was released by the government after the Section 42A report had been produced and filed. In my submissions, I've stepped through the Council's position with respect to how this hearing panel should deal with those new national instruments. And for the record, those instruments are the National Policy Statement for Freshwater Management 2020, the Resource Management National Environmental Standards for Freshwater Regulations of 2020, and the Resource Management Stock Exclusion Regulations 2020. I want to touch briefly on the NPSFM. The Council is required to give effect to national policy statements, including the National Policy Statement for Freshwater Management 2020. A question that this panel will need to work with is how and to what extent should that policy statement be given effect to. In my submissions, I've addressed this issue, and in short, it is my submission that the hearing commissioners should strive to give effect to the NPSFM 2020 where there is scope within submissions to do so. With respect to the NPSFM 2020, there was also a direction for councils to make amendments to their plans without following the Schedule 1 process and insert provisions relating to natural inland wetlands, rivers and fish passage. The directions with respect to those provisions are set out at clauses 3.22, 3.24 and 3.26 of the NPSFM. By resolution dated 24 September 2020, the Canterbury Regional Council resolved to make the changes that it had been directed to make to its regional plans with respect to the insertion of these provisions. A public notice setting out those changes is now placed on the council website, and an advertisement was included in newspapers circulating in the region yesterday, Monday, the 28th of September. A copy of the public notice will be made available to the hearing commissioners and added to the council website just as soon as possible in terms of the PC7 portal. And I understand a copy of the notice has been handed up to the commissioners who are in the room today. The second national instrument is the National Environmental Standards for Freshwater Regulations. Those regulations require councils to identify conflict between those regulations and planning provisions. Again, the council is required to make changes to its plans without following the Schedule 1 process if there is duplication or if there is conflict, which can either result in provisions being more stringent or more lenient, depending on the particular provisions. As set out in a memorandum of council filed a week or so ago, the council has undertaken the assessment of duplication, and for the most part there is no duplication between the provisions. There's one exception to that in relation to a provision in the Waimakariri River Regional Plan. With respect to conflict, the conflict assessment has indicated that there is at the most partial conflict with respect to some activities in some of the planning provisions. That analysis continues to be undertaken, the outcome of which will be that if there is conflict or partial conflict that needs to be addressed by amending provisions of plans, including proposed plans such as Plan Change 7 and Plan Change 2, the Council will, by resolution, resolve to make those changes. insofar as changes are made throughout the course of this hearing process, we will bring that to the attention of the hearing commissioners as soon as that has occurred. For completeness, the final instrument that formed part of the package for Action for Healthy Waterways was the Resource Management Stock Exclusion Regulations of 2020. Those stock exclusion regulations are also addressed in my opening legal submissions. And whilst no changes are directed to be made with respect of those provisions, given that they do touch on some topics that are covered in Plan Change 7, they will be a matter that submitters are likely to touch upon and council officers in reply are likely to touch on, with a view to ensuring that there is as little duplication between provisions as is appropriate based on the evidence. Finally, in my opening submissions, I recorded that there have been a number of documents filed following the provision of the officers' report and documents that the council officers, particularly technical officers, had participated or co-signed, and those relate to documents following the expert witness caucusing. In terms of those statements, those have been provided to the hearing panel and uploaded to the PC7 website. Those are that is the opening statement that I wish to make, and I'm happy now to answer questions on the legal submissions that are either contained in the Section 42A report or in the legal submissions that have been previously circulated.
Well, thank you, Mr. We particularly recognise the fullness of the submissions that you've given us today and provided to us in writing 2 or 3 days ago. And at the same time, acknowledging Mr. McCallum-Clark beside you, the commissioners acknowledge the thoroughness and comprehensiveness of the materials that Mr. McCallum-Clark and his team have been providing to us as the Section 42A report and various responses to questions that we've already been directing in respect of that. Of course, that doesn't mean that we necessarily will adopt all of the recommendations in it, but it's right that we should acknowledge what a thorough and helpful and clear material he has provided to us. Now, although we've already asked you some questions, Mr. Moore, and had responses to them, and they will be on the record, there will be further questions that we now wish to proceed to, and so I'll invite Commissioner Van Voorthuizen to ask any question he has first.
Yes, thank you, Chair. I've just got one request and 2 questions relating to the opening legal submissions, so I'll put those to you first, and then I have about 20 questions arising from the answers to our pre-circulated questions and the joint witness statements, which I suggest I put to you after all the legal questions have been dealt with. So the opening legal submissions, firstly at paragraph 35, and this is a request, and I would appreciate it if the officers could compile a table illustrating how the PC7 Table 1A and 1B management units relate to the NPSFM 2020 Appendix 2C Tables 23 to 25 or 6. I can't read my own writing. I was just having trouble relating how those different units mesh or don't mesh. And if that could be done reasonably early in the hearing process, that would be helpful. The next question is at paragraph 58. And I'm just looking at the second sentence of that, retaining rules that are more stringent may be appropriate, etc. And I was just wondering, has any analysis or further analysis been done of that particular issue?
So this is the stock exclusion regs in terms of planning provisions and whether they're more stringent. CEAN's been undertaking that, but I don't have it to hand. I understand that some analysis has been undertaken, but neither Mr McCallum-Clark nor I have that analysis to hand.
Mm-hmm.
If it would assist, we could treat that question as a request, much like the first request, provide that just as soon as possible.
Yeah, that would be very helpful, and I think in your verbal comments you anticipated that submitters are likely to raise the same question, so as soon as we have the council officer's position on that, the better. And then my third question relates to the provisions that have been inserted into the plan as required by the MPS 2020, so the provisions relating to wetlands, rivers and fish passage. And forgive me if you've already answered this in your legal submissions, but my question is, what, if any, consequential amendments are required to the PC7 provisions to ensure consistency throughout those provisions? Has an analysis been done of that?
I'm unaware of whether any analysis of consequential changes required has been undertaken at this point in time. Again, I will make some inquiries and report back.
Yeah, thank you. And for example, the fish passage provision inserted by the MPS FM 2020 being objective would have widespread application throughout the document, and my initial review of the wording in the MPS provisions compared to what's already in the plan by way of policies and rules would suggest that there would need to be some amendments to ensure consistency.
Yes, for example, the changes to policy 101, 102 and around that part.
And the rules that give effect to those provisions.
Sure.
So, all right. So just in terms of that, do you have any idea of timing when we might see those, the further analysis or being done?
Get that done in the next 1-2 days. This week? Yeah, this week. This week?
Excellent. So thank you, Chair. There were my questions for Mr Moore and his team. So maybe if I leave my questions for the officers until yourself and Commissioner Solomon has dealt with any legal questions, that would be appropriate.
Yes, that's fine. Yes, thank you. Commissioner Solomon?
Yes, thank you. I refer to Council's memo, the first part of paragraph 30, where it says, further, in giving effect to Te Mana o Te Wai, the Council must actively involve tangata whenua in freshwater management, including decision-making processes. What do you consider is meant by decision-making processes in this context?
The language used in the NPSFM with respect to reference to decision-making processes is broad, and in my submission captures a wide range of decisions that councils make with respect to the implementation of the NPSFM. The decision-making may occur early on in a process in terms of the identification of values, right through to the articulation of those values in planning documents. It's not directed solely at simply plan-making functions. In my submission it's broader than that, and consistent with that is the need and the requirement in the NPSFM to develop local understandings of Te Mana o Te Wai, and there will be decision-making opportunities as the local understanding of Te Mana o Te Wai is better understood across the region.
Okay, thank you. Regarding the CWMS, how soon will giving effect to Te Mana o Te Wai influence ZIPs?
In terms of the future council work programme with respect to ZIPs and further addenda to those ZIPs, and I must say I'm not familiar with the future work programme, but insofar as there will be a future work programme, the obligations now set out in the NPSFM I would have thought would inform the contents of ZIP and zipper documents moving forward, because the reality now is that with respect to plans, the obligation to give effect to Te Mana o Te Wai is a stronger obligation again than the obligation that existed with respect to the previous iterations of the NPSFM.
Regarding the three clauses, fish passage, natural wetlands and loss in rivers and their values, I presume that will apply to all ZIPs now?
These are the clauses that are to be inserted into the
Yes.
planning documents.
Yes.
So those clauses are not inserted directly into the ZIPs themselves, they're inserted into the planning provisions. And if you have, I'm not sure, do you have a copy of the public notice
Yes.
there? You'll see in the very first paragraph there a series of bullet points which indicates the documents within which these provisions will be inserted.
Okay, thank you. And just one more, perhaps it's not for you though, perhaps it's for an ecologist. I just want to know what classifies wetlands as natural and how far inland is an inland wetland. And I ask because I want to know if a reinstated or a partially reinstated would be considered natural.
As far as I can advance matters, I'd simply point to the definition of natural inland wetland in the NPS, and it is defined there as meaning a natural wetland that is not in the coastal marine area. And that is a very broad definition, and it strikes me that that will be all wetlands that are inland of the coastal marine area, so there won't be an inland cut-off, if that makes sense. In terms of an ecological response to that question, I'm unable to assist in that regard, but perhaps I could have that question re-put to one of the council ecologists once the questions of the legal team and the planners have concluded.
Thank you. That's all from me.
Thank you.
Thank you. I've got a few that I would like to ask you, Mr. Moore. And the first one is quite a minor one, but it didn't seem to be quite clear to me, or quite right. If you would go to paragraph 44 of the submissions that you presented to us today, you'll see in the second sentence reference to the legislature approving the NPSF in 2020. And technically that didn't seem to be quite right. Is it that in fact the NPSFM is approved by the Executive Council and not by the Parliament?
Yes, that is correct.
So is it the legislature that we're speaking of here?
No, sir.
That's all right then. I think we're at one on that. Now, I wanted to ask another question that I made a note of a few days ago. The RMA entrusts the Regional Council with the management of freshwater resources in its region. There are submitters who propose that a certain function of that management should be delegated by the regional plan to a private company, or Puha Water Limited, to be exercised in certain circumstances at its discretion according to stated criteria. Now, however knowledgeable the current management of that company may be, and however justified it may be considered for the company to exercise that function, would the council have authority by law, either by sections 33 to 34A of the RMA or otherwise, to devolve on a private company that function of its management of fresh water?
No.
Well, that's a straightforward answer. Thank you. It would in fact be an unauthorised sub-delegation, would it?
Yes, that would be my submission.
Yes, all right, thank you, that's good then. Another issue that was discussed in respect of the Section 42A report, and referring perhaps to Christchurch City Council's submission, raises the standard for drinking water. And I find myself a little bit unsure about that. Can you tell me what is the drinking water standard? What is the authority for it? What is the text of it? How was the standard reached? In other words, is it based on a median or a mean or something like that in terms of effects on the health of the population? And would a precautionary approach be permissible in respect of that issue?
Are you in a position to answer the technical side of that? No. Okay, that's a written response. Yeah. There are two components to that question, the first of which
Yes, I'm
relates
sorry, it's a bit complex.
relates to technical matters that are beyond my legal expertise in terms of how the drinking water standards have been prepared with respect to Plan Change 7. In order to answer the second question as to whether a precautionary approach should or shouldn't be taken, I'd be reluctant to provide an answer to that until I see the explanation for the way in which the standards have been formulated. What I propose to do is to take some technical advice with respect to the question, and I'll provide an answer in writing, picking up on the second and the legal element being the precautionary approach.
Thank you very much. Next, I'm referring to a submission by a submitter called As One Incorporated. And they refer to an argument from section 80 capital A concerning collaborative planning process. But I understand that a few weeks ago, section 80 capital A was replaced by a different section addressed in the section. And I don't think that replacement you will have had time to address in the section 42A report. But I just wonder whether you'll be able to help me to know whether or how we deal with that point, that submission point raised by as one incorporated, in view of the replacement of the section that they seem to be relying on.
With respect to reference to a collaborative or to that collaborative planning process, as I understand it, that was a process introduced into the Act in or around 2017.
Yes.
Plan Change 7 and Plan Change 2 are not following the collaborative planning process. It was a separate option for running hearings. So insofar as the reference in the submission is to collaborative or that collaborative planning process, my submission would be that it is irrelevant for present purposes. It may well be, though, that the context within which that submission is made is speaking more broadly about collaborative planning processes, perhaps referencing the work of the Zone Committee in the context particularly of Part C of this plan change. I would need to reread the submission to understand the context before I can provide a final answer to the question. Perhaps a preliminary view, though, if the provision itself in terms of Section 80A has been removed from the Resource Management Act and the transitional provisions do not provide any guidance with respect to the ongoing operation of those provisions, then again the submission would not provide much guidance, or the relevance of the submission would be very minor, if non-existent in this context.
Well, thank you for that. Perhaps the way for us to proceed is to see how As One Incorporated presents the point when they come to speak to their submission. And then, of course, you will be considering it in respect of a reply at the end of the process. And that might be the time for you to refer back to that again if it's still cut.
Yes, that would be suitable in the context.
Well, I think that deals with questions that I was wanting to ask at this stage. And I wonder whether it's convenient now if we come back to the technical questions that Commissioner Van Voorthuizen has to ask of members of the CLWRP team, if I put it that way.
Yes, thank you.
Yes, thank you, Chair. So the first series of questions relate to the large questions and answers document, the 85-page document that was circulated.
As you'll be aware, there are a number of technical authors.
Yes.
So we provided you with a sheet of who was the sort of the lead author on different topics. Even within that, there are people who cannot answer all of those questions. So
Sure.
we've got the whole team here,
Yes.
and there'll be a bit of musical chairs if that's right with you.
Yeah, that's what I hoped for and anticipated. And I understand that the relevant experts have read the submitter evidence that's relevant to their topics, because my questions assumed that they have.
There may not be significant and in-depth understanding of the evidence that has come through. The instructions that I generally give is that the council will deal with evidence once it's given and then in reply.
Right.
But they may well have read some of that evidence in preparation for the caucusing, so we'll see how we go.
Sure, and if the relevant expert hasn't read the evidence that relates to the question, then I'm happy for that to be responded to either later in the hearing or in reply.
Thank you.
So looking at the large 85-page document, I've got about a dozen questions from that. The first one is on page 6. And it's at the top of page 6, the last sentence, where it says, further information, particularly from Ngā would be beneficial to confirm if this definition is fit for process. And the question is, has that evidence been provided and have the relevant experts considered it regarding that definition?
If it's permissible to you, for some of the simple questions, I
Yeah.
could possibly turn around and get an answer.
Sure,
Um,
sure.
Hello.
This is Ms. Dawson.
So from a technical standpoint, I guess from an ecologist perspective, there hasn't been ecological advice sought on this. This was largely getting at seeking advice from Ngā about their cultural concerns and how they would define springs that they seek to be protected. And at this stage, from my reading of the evidence, there isn't a definition, I guess, that we can adopt right now.
Right, thanks for that. So my next question skips down a few pages to page 22. And this will be an easy one for you to do, Mr. McCallum-Clark. You see there at the top of the page there's a little clause B, and it's got a strikeout and an underlining, but the underlined words are exactly the same as the strikeout words, so I'm just kind of wondering what was intended there.
I can confirm that that was an error, and the consolidated version of the plan change that we've given to you of the track changes doesn't include that.
So the words to be struck out, or are they to remain?
The words are to remain.
Okay, thanks. And I could have looked at the consolidated version, but I thought you might know off the top of your head. So next question, page 24. And I'm towards the bottom of the page. And the issue is this terminology, minimal, more than minimal, or no more than minor. And so having read the answer, my question is, can the officers provide an example of an effect that is not minor but is no more than minimal to help me understand their advice?
I see that.
And I'm happy for you to think about that and come back.
Yeah, we'll take some time just to find a suitable example.
If there is one. Page 35. And this is quite a broad question, but have the officers had an opportunity to reconsider their advice and conclusions regarding the regulation of vegetable growing in light of the evidence that's been lodged so far from parties such as Mrs. Kickstra, who we're going to hear from this afternoon, Hawke New Zealand, Potatoes New Zealand, etc. Given the concerns raised by those submitters, has there been any reconsideration of the issue by the officers? And so, Mr. Moore, sorry, just before we have the answer, this is one of a number of questions that I'm posing of a similar nature, or normally these issues would be dealt with in reply. I'm keen to know if the officer's advice or thoughts have moved before we hear from the submitters. Okay.
Sure.
So just to clarify, I'm providing planning advice, and the question is about the pathways for consenting or regulating commercial vegetable production?
More about the outcomes that the submitters have raised concerns about regarding the restriction on the ability to grow food and the need to be constrained within certain zones or nutrient management areas, etc. So it's the whole bundle of concerns and the outcomes they produce. Really.
Yes, certainly. I guess aspects of the 42A report and my thinking that was documented there has moved, and I would like to canvass them in the reply. And to hear, I guess, from the submitters themselves during the course of the hearing. If you had a specific question, I guess I could answer that now, but in terms of, I guess, the outcomes, I am waiting to hear from what the submitters have to say here.
So you said your thoughts have moved. How have they moved?
Specifically, that's in relation to providing or I guess investigating whether or not we can provide multiple pathways for authorising commercial vegetable growing. That's certainly something that's been raised by Horticulture New Zealand and a couple of other submitters where they raise the issue that people may have already authorised their growing activities through a land use consent.
All right, thank you. Page 51. And it's in the second box down, so it starts with the bold words "is the main outcome of the 42A changes." And so this is another one of these broad questions. In terms of the recommendations to us, i.e. this relates to the OTOP region, moving the 2025 changes to minimum flows and allocations to current and the 2030 ones to 2025, and the need at all for the 2030 changes, in light of the evidence received from a number of parties, particularly Opua Water, FAWP, the Adaptive Management Working Group, have the officers had any reconsideration at all of their recommendations to us in that regard?
Not so far.
Page 53. So it's about halfway down the page there's a line, and underneath the line it's got 323 and then 10.11, but I want to ask about the paragraph just above that. And it talks about a new policy which could provide clarity on the regime by amalgamating three policies. And have the officers given thought to what such an amalgamated policy might look like, and if not, could they please and provide us with some wording?
I have not pulled that together yet, but I am happy to do so and provide it to
great.
you possibly before the start of the next hearing week.
Sure. Yeah, no rush for that one. Thank you. Page 57. So right down the bottom of the page, and the box is 369 12.153. And the words in the second paragraph there, we acknowledge there is room for improvement in the drafting of clauses A and B and the subsequent rules, etc. So similar question. Have the officers had a chance to consider wording, and if not, could they do so we can see what it might look like? Page 62. So top of the page. About 4 lines down, upon reconsideration, we recommend that if the T block is removed, etc. And then it refers to a bespoke rule. So very similar question. Can the officers provide us with some wording of what this bespoke rule might look like so that we can take that into account when we consider this matter going forward?
Yes, I can do that. Might I also highlight that there was a memoranda produced by the Regional Council just a few days ago that highlighted that there may be, that on the basis of some work on the resource, an update to the resource consent inventory, which has changed some volumes of water allocated in the Regional Council's calculation, which may also be some wider context to this issue as well.
Okay. So maybe when you draft the bespoke rule, if you can add some text in to refer to the memorandum you just referred to, so we can have the context for that.
Very good.
So when was that memorandum dated?
It was filed by the Regional Council 23rd of September,
Okay.
so very recently.
All right. Page 71. So right down the bottom of the page, again, similar question. Should the hearing panel consider more explicit reference to when loss reductions is necessary, then a similar amendments would also be need to be made to Rule 8.5.26. So can we just see what some wording on what those amendments might look like?
I can provide that at the same time as Mr McCallum Clark.
Yeah. So you can see a lot of the questions are just about fleshing out some of the if or maybe advice to us so we can see whether or not we like it. And so now, just before I turn to the joint witness statements, a more general question relating to Table 8-9, which you don't need to turn to, but it's the nitrogen loss reductions for the Waimakariri nitrogen priority areas, I think they're called. Have the officers had a chance to consider the evidence received relating to the 2050 onwards reductions in that table and the possibility of having a policy whereby those further future reductions, the post-2040 ones, would only be implemented if progress towards the nitrate limits and targets in tables 8.5, 8.7 and 8.8 are not being achieved by January 4040. That was a significant and consistent theme coming through from the evidence on that particular table from submitters. So has any thought been given to that?
At this stage, I haven't formed a view on a type of policy that would provide for that situation. Something that I'd like to address and reply once we've heard from the submitters on that.
Okay. So when you think about that during the hearing and listen to the evidence that we'll hear, two things perhaps to bear in mind in that regard is that at the joint witness statement, the Christchurch Waimakariri joint witness statement, the experts seem to agree there was a basis for a larger NPA, so indicating that the current one might not, the current amalgam of them might not be big enough. And also an issue raised by submitters was that if their reductions post-2040 were removed from Table 8.9 and a policy instead was used to consider them should the targets not being achieved, then it would be possible to collapse Table 8.9 into one row because the first two columns are all the same. And then submitters, particularly from Waimakariri Irrigation Limited, raised the issue that they're concerned about having different provisions applying to different parts of the land covered by their irrigation scheme, because that cuts across the way they want all of their people to work together. So it's creating a hierarchy of haves and have-nots, which is counterproductive. So if you could bear those issues in mind as the hearing proceeds and make sure that they're thoroughly covered in the reply advice that we received. All right, so now turning to the joint witness statement, so just 2 or 3 questions from each of those. So maybe if I deal with the water quality one first. So that was the joint, I think, water quality ecology caucusing. And just wait, someone can indicate if you've got it there. So you're ready for the question? First question is at paragraph 16. Oh yeah, Ms Hayward, come on up. Given that the experts seem to agree that dissolved oxygen concentration was the better metric, and in fact the MPSFM 2020 pretty much makes that crystal clear, should all of the tables relating to dissolved oxygen that are affected by PC7, should they all be changed to use dissolved oxygen concentration?
I agree that that would be a sensible approach to undertake at this time, that we have the opportunity to do that. So I am happy to come back with some recommended provisions. Yep.
Yeah, that'd be very helpful, and then we can have that sitting in front of us as we hear from submitters. That would be great. And on that same WS, paragraphs 18 and 19, there was obviously some disagreement amongst the experts there. Has there been any further resolution of that disagreement, or is this pretty much where things are at the moment?
Correct. This is where the situation is in terms of our views.
How would the officers propose that we as a panel would resolve those differences, given that we have qualified experts on one hand and qualified experts on the other hand giving us different advice?
That's our job.
Is there going to be any further discussion, or is it just going to be left to us to consider as the hearing rolls on?
One of the matters that we didn't resolve but didn't necessarily disagree on, we just hadn't had time to consider, which was how you might define the dissolved oxygen concentration, frequency and averaging period.
Yes.
So I'm happy to propose, to put forward my view on what that might look like, and other parties could respond to that.
Yeah, that'd be helpful. So that was the paragraph 19 issues, wasn't it?
That's correct. Yep.
Okay, that would be great. And very simple. And paragraph 21, there seemed to be agreement that table 14B should be amended or could be amended. The experts agreed on a number of matters there. Can we get an amended table 14B from you as well, so that we can have that sitting there?
Yes.
Thanks. So that was all from that joint witness statement. The next one is the hydrology one. So first question is at paragraph 29. So second sentence, using a different averaging time period on the main stem compared to the tributaries causes additional compliance monitoring complexity. So there's a problem. Do the officers have a solution for us?
Yes, the most straightforward approach is to use the same averaging time period for all parts of the catchment.
And that would be what?
12 24 hours is what we use across the rest of Canterbury.
Okay. Mr. Moore, this is a bigger question. It stems from paragraph 39, but also from the larger questions and answers document, particularly pages 51 and 52, and it relates to the alternative management regime, or levels 1 and 2, and table 14X. And the larger questions and answers document fairly strongly indicated that the provisions in the plan as notified were quite complex and unusual for a regional plan. You would normally more normally see them in consent conditions. And so my question really is that from stemming from paragraph 39, given the complexity of that notified regime, the fact that certain submitters don't agree with it, but there was no resolution by the experts on what the table 14X triggers should be, or indeed what the level 1 and 2 flows should be, does that lack of agreement lead weight to the thrust of what I took from the questions and answers document, that complex regime would be best dealt with in a consent process rather than a regional plan?
Yes, it probably would.
And I understand the existing consents expire at 2030?
2031, 2030? 2031.
There'd be no impediment to the consent holder seeking a review or a change to conditions prior to that to insert an appropriate alternative management regime into their consents?
There would be no legal impediment from seeking that change.
And in terms of the business as usual or full availability flow regime for Sale Yards Bridge, my reading of the officer's advice to us is that they agree with the regime proposed by the Alternative Management Working Group, if I've got the name right.
Yes.
Okay. I might have used the wrong acronym there, but is it those two parties? Okay. All right, now just moving on finally to the Christchurch Waimakariri JWS. So first of all, who we got here?
Introduce yourself.
So Zeb Etheridge, I've been the groundwater scientist on this process.
I'm Emma Kreliger, I'm a senior groundwater scientist for Environment Canterbury.
Excellent, thank you. So my reading of paragraphs 35 and 36, and this relates to the issue of whether or not groundwater is going underneath the river from the north and influencing the groundwater under Christchurch City. So my reading of the JWS in those two paragraphs is that all of the experts, some of the experts say yes, that is happening, and some of the experts say maybe that's happening, but none of the experts are saying definitely that's not happening.
Exactly so.
Is that a correct summation?
That's a fair summary, yeah.
Okay.
Yes.
Good. Paragraph 56. The experts agree that greater nitrogen loss reduction rates could be required to meet the new national standards, And my question is such as?
Greater nitrate loss reductions could be required for those receptors that will end up with lower limits.
Yeah, my question is what are the greater nitrogen loss reduction rates that could be required?
So one example would be Silverstream, where currently proposed is the pre-existing bottom line of 6.9 milligrams a litre. So if we're going to the new NES, then that's roughly a 50% reduction. So we'd have to increase the nitrate loss reductions by a similar amount.
Okay. So, Mr. Moore, are the officers able to provide a fulsome answer on that? So were any of the existing provisions in the plan changed, are affected by that particular clause? Can we just get a breakdown of what the experts now think might be required?
Sure. Yes.
And the very same question for paragraph 57, if that was a different issue, but not sure if it's a different issue or the same issue, but the same question. Can we get a detailed breakdown of where the experts now think that the numbers need to be in terms of the agreed matters there? And thank you, Chair. That's all the questions I had arising from the information provided to us to date by the officers.
Thank you. Thank you all for the contributions you've made to our questions, and some you've answered right away, and some you're going to come back to us on sooner or later. So where are we now with our timetable? Do you have any further questions, Commissioner Solomon?
Yes, I have questions for the three joint witness statements for hydrology, freshwater ecology and the Waimak. The Waimakariri. Sorry, I'll just bring them up. So for hydrology for the Orari Temuka or Pihi Pariora sub-region, I've just got 4 questions. And I refer to the memo of CRC Council dated 23rd of September relating to the OTOP RCI and well search under implications of the difference, where it says the new method will result in allocation being available in both the levels plain and Orari Ōpihi groundwater allocation zones. This available allocation could be applied for by any party, including new abstractors. Could this groundwater allocation be used for a Mahinga Kai allocation, particularly when the allocation will remain in the system until surface water levels have improved as per 4.43 in the Section 42A report?
So this memo explains the new accounting method, which highlighted those 2 zones have allocation available. Because it's available, it could be applied for by anyone currently. If there was a purpose for Mahinga Kai improvement, that could be applied for as well. The planners may have further advice on that, the planning side.
In terms of this being a groundwater amount of groundwater available, I would need to recheck submissions, but I'm not sure that any submitter has sought that there be a Mahinga Kai allocation for groundwater. Would be my only concern with that.
Okay, thank you. I refer now to paragraph 30. You talk about headroom in the notified BN allocation. Could this headroom, if it were to remain in the river, be large enough to meet in-stream needs?
So the headroom is basically allocation within the block that isn't applied for. Because it is a BN block, it is a high flow allocation block. So if that water was left in the river, it would not be impacting your lower flows. That makes
So
sense.
it could be good for in-stream
It
ecology. Okay, thank you. In paragraph 34, how often is the river mouth open and what volume of water is needed to open the mouth? I think the ecologist said a minimum of 6,000 litres a second. Is that right?
So that's the number that's used quite frequently for a flow that keeps the mouth open.
Okay.
In terms of what is required to open it, I'm not sure what flow number that is. Quite often it's mechanically opened.
Okay, thank you. And then paragraph 39, and I'm not sure if I'm asking this question in the right way. Could a lake level methodology be developed to enable a trigger for an ecological health outcome in light of moving forward for Te Mana o Te Wai?
So the ecological health outcome would be dependent on the river flows. There may be some lake variables that could be influencing that health outcome. What we were discussing in paragraph 39 is the difference in opinion between whether setting a lake level trigger based on management experience or whether we base it on historic data was appropriate. Both of them had their challenges, hence the non-agreement on that one point.
Okay, that's all for the hydrology. Thank you. Freshwater ecology, freshwater quality and ecology in the Orari Temuka Ōpihi Pariora sub-region. Paragraph 36, long-tailed bat. Is it a localised colony? Okay. Paragraph 39, aside from regular mouth openings and mid-range flow variability, what other components of a flow regime does a healthy ecosystem rely on?
So the various components of the flow regime include, as discussed in the joint witness statement, the base flows, or how low the flow gets, and the habitat that provides for. In terms of mid-range and other flow variability, they are important for a range of ecological purposes in terms of stimulating fish migration, enabling fish migration through appropriate water depth, and particularly in terms of supporting an open mouth to the sea so that fish can migrate in and out. There are other benefits that flow variability provide in terms of flushing and cleansing the riverbed, so that's both cleansing, nuisance periphyte and fine sediment deposition, reaeration of the water column, so introducing oxygen or refreshing the oxygen levels. So a range of, I guess the point there was that it's not just a minimum flow that's important.
I got that point, thank you. Paragraph 51, what is deemed as Mahinga species? And if Mahinga species are to be provided for by incremental gains in flows, is there a symbiotic relationship between Mahinga species and other native species mentioned in the same paragraph?
So in terms of the reference there to Mahinga kai species, we were thinking specifically around tuna, longfin, shortfin eels, and different life stages do have different flow needs, or the habitat provided provides different habitat availability for different life stages and seasonality. But as a general rule, in terms of providing for Mahinga kai species, you will also provide for other native species as well.
So is there an interdependent relationship between Mahingakai species and other native species?
In broad terms, yes.
Yes. Yeah. Thank you.
Thank you.
And now just a couple of questions for the groundwater science in the Waimakariri sub-region. Just hang on a minute while I bring it up. Paragraph 32. Can you explain that to me in lay terms, please?
So paragraph 32 of the joint witness statement is talking about how we pulled some information from our groundwater model to get an idea of how much water could be flowing from the Waimakariri Plains beneath the Waimakariri River into the Christchurch aquifer. And so the model recognises that we have a lot of uncertainty about these things, but tries to capture that uncertainty by giving us a range. And that range is 2.4 to 5.7 cubic metres a second, which was somewhere between 17 and 25% of the total amount of water flowing through the Christchurch aquifer. So does that help?
Yes, it does. The confidence intervals were confusing me. 90% confidence, and I didn't know what they meant, but you've explained it. Thank you. And just paragraph 33, you talk about potential. How potential is potential? Like if you were to put a percentage on it, what percentage would you use?
So I suppose I tend to work with these kind of questions in the strength of the evidence that we have. And in this case, we went through a very rigorous process of multiple different models to assess this, plus bring in a panel of experts and so on. So in relative terms, I'd say there's a strong potential. We're always dealing with a lot of uncertainty in groundwater science, but relative to, I guess, groundwater science generally, this is a fairly strong body of evidence pointing towards that conclusion.
Pretty much speaks for itself. Paragraph 46. Is the Irwell Forest area where Ngaitahu farms are?
Correct, yes.
Thank you, that's all.
So is there anything further that we can trouble the Environment Canterbury people with this morning? Is there anything further that you would like to say to wrap it up at this stage, Mr. Moore?
Just there might be one outstanding issue in relation to wetlands, and there was an ecological component of a question that Commissioner Solomon put to me. Would you be assisted if we made available one of the council's ecologists and you can put your ecological question to the council ecologist?
Yes, please.
Right. A written answer will be provided from a wetlands expert to best assist.
So will the answer include what a natural wetland is, what a reinstated wetland is, and how inland is inland?
Yes.
Okay. Thank you.
There are no other matters that I wish to address you on in opening. Nothing else from Mr McCallum-Clark. Thank you for the opportunity, and we will have the responses to questions provided just as soon as possible in terms of the outstanding matters.
Well, thank you very much. Thank you for the submissions. Thank you for the answers. And thank you for all of you who have attended in case there were relevant questions for you. So I think we break now and we resume at 1:30 for the submission of Mr. Hamilton.